Maybe not on the screen.
Is anyone seeing Mr. Rademacher?
I can see Attorney Rademacher, Chief.
You can?
I can see him, yes.
Okay.
But I
cannot.
cannot see Justice Mullins or Justice Keller.
Okay, it's one of those artifacts of this particular platform. So we'll proceed. Each side, this is the matter of State of Connecticut versus SILVA. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Senior Associate Justice McDonald will be our timekeeper. Please, thank you, Justice McDonald. The justices will ask questions by either raising their hand where you can see them or virtually raising their hand. Once you see that, please stop your argument, and then I will call on the justice to ask their question. I don't think this is a case where there's an issue of identifying information, but if there's any identifying information that should not be made public, then I expect counsel will respect that and not make the information public. We are trying to make these hearings as transparent as possible and do as many as we can on the video platforms. Are the parties ready to proceed?
Yes, Your Honor.
Mr. Rademacher, whenever you're ready.
Counsel, you're muted. Counsel, you're there. You go.
All right, I'm Mark Rademacher, Assistant Public Defender. For Mr. Silva, I'd reserve 5 minutes for rebuttal.
Thank you, Mr. Rademacher. You have your 5.
Now, turning to the first issue involving the instruction on the element of multiple murder, the defendant was charged with only one of 2 alternative sections of murder with special circumstances. Namely, he was charged with committing 2 murders in the course of a single transaction. He was not charged with committing 2 murders at the same time. Nonetheless, the trial court gave an inappropriate instruction. The court said that the courts equated at the same time with the element of a temporal nexus or continuity between them based on time. It claimed to have found this requirement in the court's decision in Campbell. What it did was it conflated the 2 alternative elements, only one of which was charged in this case.
Mr. Rademacher, hold on, please. Justice Kahn.
Thank you, Chief. Attorney Rademacher, other than what beyond the statutory language, in your view, suggests that it must be more than temporal proximity?
Well, this court's definition in Campbell states that to constitute a single transaction, there must be some clear connection between the murders so that they can be viewed as part of a series of related and separate events. It anticipates, well, the classic example would be 2 murders during the course of a robbery. And the transaction is the beginning and end of the robbery. When you don't have an underlying felony, the beginning and end of the plan, perhaps, is the time frame within which the interaction between the defendant and the victims must occur.
But what if the plan is just that? The plan is to kill 2 people or 3 people. I mean, the plan doesn't have to be a robbery. There
Correct.
doesn't have to be a separate underlying offense. So I guess I'm struggling with, why temporal proximity alone wouldn't be enough. I mean, I understand the statute is written one or the other, but isn't there really an overlap? It's 2 ways to prove the same thing.
Well, it requires something more than temporal proximity. In other words, the same transaction doesn't require that they be close in time, but it also does not say that a temporal connection in and of itself is sufficient to prove the same transaction element.
So if someone committed 2 murders 8 months apart, that could still be part of the same transaction?
I doubt that.
So then you would need both, right? Temporal proximity and a plan, part of the same plan.
An example of where they occur at the same time, and an example of where 2 murders occur at the same time, but pursuant to a plan, is where you kill one person and then you kill the other as a witness. And another one would be where there's a sexual assault and then you kill the victim.
The sexual assault example wouldn't be 2 murders. It would just be one, right? A sexual assault and then a murder. That wouldn't fall under special circumstance.
Well,
You need
that was
2
an
murders,
example.
right? Okay. You mean maybe a sexual assault with a witness and then both are killed. Is that what you were trying to say?
The court in a prior case used that as an example of a logical connection between a murder, in that case, a sexual assault. And the plan was, say the plan in this case was to kill one person and then eliminate a witness. That needs more than temporal proximity. It needs a plan to get away with the crime by killing an eyewitness.
So your position is that temporal proximity alone is not enough, and I was trying to understand what beyond your reliance on the statutory language would suggest that, if you had any cases. And you mentioned the Campbell case, but was that more based on a plan?
Yes, the plan there was to eliminate the eyewitnesses.
Right.
To
So
another.
it wasn't a case based entirely on temporal proximity, was it?
Well, in that case, both were charged, and the issue came up in the context of whether the statute was vague. And the 2 other main cases, Gibbs and Ferguson, there were, in one case, 2 murders followed by an interval in time and 3 more murders.
I guess, and I'll end because maybe my colleagues have questions. I don't see hands up, so I'm going to just throw one more question at you because
Sure.
I'm trying to understand this, which is, do you have any case that says temporal proximity alone is not enough?
No, but I think that the argument there is you have 2 sections of a statute. We read the statute so that every provision has meaning. And if you conflate the 2, then you're eliminating some statutory language, namely, at the same time, rendering the statute, part of the statute, superfluous. And that's not how we read statutes. And
But you could charge both. And I understand your argument here is they only that at least the charging document relied only on the second, but the state could charge both ways to prove the same thing, correct?
I don't know why they didn't in this case, but I don't. They charged it in one way. The defense planned its case around the defense that there was no common plan, intent, or motive behind the 2 murders. So by enlarging the statutory language to include at the same time, they deprived the defendant of one of his main defenses.
But did he really have a defense that these were not temporally connected? I mean, I understand he prepared a defense that this is not part of the same plan, but is that really in dispute here?
No.
That there was temporal proximity?
No.
So how was he harmed?
Because
In terms of preparing a defense, because I don't see a defense to the temporal proximity. His defense was, I didn't do it, Opalka I'm probably mispronouncing that.
I think it's Opalak.
Opalak did it. I didn't do it, but it seems to me he didn't really have a defense to temporal proximity, did he?
Well, his main defense was, I didn't do it, Opalak did it. The secondary defense
Oh,
was,
please
based on-
finish answering, and that'll be the end of my questions. I see one of my colleagues has his hands up, but please finish the answer. I just wanted to alert that would be my last question.
you plan your defense around the charge and the elements. They alleged a single transaction, and the defendant prepared his defense based on that allegation. And he attempted to prove, and I think he did prove, there was no common motive, intent, or plan in the two murders. This type of an error is, first of all, not subject to harmless error analysis. First of all, it's reviewable as plain error, and plain error does not admit a reason of harmless error analysis.
Mr. Rademacher, you're muted.
You're muted, and Justice
Okay.
Acker has a question too, I think.
All right, I was addressing whether the issue is subject to harmless error analysis. And in this case, the defendant was convicted of a crime with which he was not charged, namely murder, two murders at the same time. He wasn't charged with that, but that's what he was likely convicted of. And what he was charged with was a single transaction. And that likely was not proven.
Justice Acker.
Yes, thank you, Chief. If I may just continue on the question that Justice Khan asked, in looking at the overlap between these two categories, the same time or the course of a single transaction. Can you imagine, Mr. Rademacher, a situation in which two people are killed at the same time, but not in the course of a single transaction?
A situation that might qualify for that would be if you fired a bunch of shots at one person and you killed the person that you didn't know was there. Kind of like the transferred intent situation.
And you don't think that would be the same transaction?
It requires a motive.
I guess what I'm getting at is whether it's possible that rather than, I'm thinking just in terms of those Venn diagrams, rather than these being two sort of separate circles, they're overlapping circles, and the overlap is such that the second category completely includes the first. The first doesn't completely include the second, but the second completely includes the first. Isn't that a sort of a reasonable way of reading the statute, so that any time that there's two murders at the same time, there will be a single transaction?
I disagree, because there must be an intent, plan, or motive. The person committing the murders has to intentionally kill that person for a reason. And that reason has to be connected with why he killed the other person. And I think part of the problem here is the judge was confusing the element with the evidence necessary to prove it. Yes, evidence of two murders at the same time is proof, not complete proof, of a single transaction. But
well, that may be taken care of by the word murder. I mean, there's a requirement of intent of murder of two or more persons. I don't know if this is the answer, but I'm not sure it's it's required by the language of the same time or single transaction. But I just throw that out there, and I think you've answered my question, so I thank you.
Okay.
Thank you, Justice Eckert. Justice Keller?
Thank you, Chief Justice. Attorney Rademacher, how do you distinguish State versus Thompson from this case, where this court talked about a misdescribed element, if otherwise supported by overwhelming evidence, makes it harmless error?
I don't know if this is a case of a misdescribed element. This is a case where he was charged with one element of the offense and not with another element. And therefore, he was convicted of something with which he was never charged. And it's also plain error to not charge in accordance with the statute in the charging document. So I think for that reason, Thompson doesn't apply. Turning to issue number 3. During his closing argument, defense counsel asked the jury this: what about Velez? Ask yourself, didn't you want to hear from her in this trial? Now, there are 2 things to notice about that statement. First of all, it's neutral on its face. He is not by any means suggesting what she would have testified to, let alone that would have been unfavorable to the state. And what it is pointing out a hole or a weakness in the state's case. Now, why is the failure to hear from Velez a weakness? One of the state's premises in this case was that there was a feud going on between Velez and Ocasio and Apolac over the defendant's affections. And Velez was at the heart of it because the defendant was seeing her, but also occasionally seeing Apolac. And the question arises, why would he get involved in this feud? Why would he take sides when he has 2 girlfriends fighting over him? Yes.
Justice Kahn?
Thank you, Chief. My question on this issue of Velez, counsel, is that the fight wasn't just over your client. They both were dating your client, but there was a lot of testimony about the entire dispute. In fact, the defense's entire theory was that the dispute, the fight was between Apocalypse and the 2 victims who were best friends with Velez. So how was your client deprived of introducing all of the evidence around the animosity between them? The evidence came in about the alleged stalking, the breaking of the windshield, all of that. So, you know, you say it's not suggestive, but saying, hey, you didn't hear from Velez is implying that if called to testify, she would have said what your client's position was. She was, in fact, still dating your client and the father of his child, correct? And was on your client's witness list. So he could have called her just as easily as the state, no? In fact, perhaps more easily than the state.
Well, I think that's irrelevant, all right? Even if she would, Ross is a good example. In that case, the missing witness was unavailable. But nonetheless, he was allowed to comment.
There was no evidence here that this witness was unavailable if
Well,
she was on your client's witness list.
Right, and when later in the trial, he tried to call her and tried to serve her with a subpoena, and the sheriff left his card. She called up the sheriff and said, I'd rather go to jail than come to court. And the judge pointed out to the defense counsel, well, if you want a capias, you've got to get in-hand service, not just left at the door.
But that's not this case, correct? That's not this case.
Yes, that's what happened here.
Okay.
So she was uncooperative, and he had no way to force her to testify. And you could sort of understand why. She's in an impossible position. She loves the defendant, and she just lost her best friend. And she did not want to come to court and testify about the whole situation. She did testify.
So she did not. So she did not want to come to court and accuse the person who killed her best friend over a fight with the man she loves.
Well, we don't know that, but I suppose that could be inferred. But in any event,
So
she was not available as a witness, but that doesn't matter.
oh, okay. But that wasn't my question. Wasn't so much about her availability. My question was, where was the defense precluded from presenting all that evidence? But I thank you for answering my question. I see Justice Doria, one of my colleagues, has his hand up, so I'm going to yield. And I wanted to note that if you want to answer more to my question, that's fine. But I just wanted to alert you, counsel, that Justice Doria also has his hand up. Thank you.
Okay.
Counsel, did you have more in response to Justice Kahn's question before I?
Well, I just want to point out that in the Ross case, the eyewitness had given a statement implicating the defendant. He was still, nonetheless, defense counsel was still allowed to argue that not calling him was a hole in the state's case. And the same situation here. One might expect Velez to testify favorably to the defense, maybe not, but that doesn't matter. The jury is confronted with the fact that there's evidence that they did not hear.
Justice Doria.
But counsel, even if that's the argument, distinguished from missing witness, I thought that after Malev, you still had to ask for permission to make that argument. And I guess I'm wondering, isn't that the reason Judge Gold shut counsel down on that?
No, you don't have to ask for permission, where you're just pointing out that to the jury the obvious. They didn't hear from this witness, but the important principle is that that can be a basis for reasonable doubt. And even in Malave, where they distinguished the missing witness argument from the reasonable doubt argument, and it's a matter of you cannot imply what the witness would testify to.
I thought Malave, clearly you used to have to do that under Secondino, ask for permission, but I thought Malave, in abolishing Secondino, said you still have to ask for permission to put counsel on fair notice that you're going to make that argument. No?
You do not have to ask permission to state to the jury, you didn't hear from this witness. That in and of itself can be the basis of a reasonable doubt. The standard reasonable doubt instruction says you can find a reasonable doubt in the evidence or the lack of evidence. And the judge's instruction negated the second half of that definition of reasonable doubt. And actually, the error here was worse than it was in Moss, because the judge told the jury, in effect, even if you wanted to find a reasonable doubt in the absence of Velez's testimony, I'm telling you, you cannot do that. And then he took it a step further by allowing the state to argue that, the defense could have called him, and why didn't they? Almost implying that the reason defense didn't call him was because she wouldn't have been favorable to him. And admonishing defense counsel in the presence of the jury that he had done something wrong when he had not.
You have 3 minutes left, Mr. Rademacher.
Excuse me?
You have 3 minutes left on your main argument, sir.
Okay. Well, there are no further questions. I'll stop here.
Thank you very much. That will go with your reserve time. Attorney Sousa.
Good morning, Your Honors. For the record, my name is Jonathan Sousa. I'm a Deputy Assistant State's Attorney in the Appellate Bureau of the Chief State's Attorney's Office. I represent the state of Connecticut in this matter. This court should affirm the trial court's judgment because the defendant has failed to show that the trial court deprived him of his constitutional rights to a fair trial or to present a defense. With respect to issue 1, I know the state raised a Kitchens argument in its brief. I don't plan on addressing that for purposes of this oral argument unless the court, of course, has questions about it. But as to the merits, to the extent that this court agrees that no waiver occurred, the state would contend that the trial court's instruction on the single transaction element was proper and, if not, unquestionably harmless. The trial court instructed the jury that in order for the state to prove that these 2 murders occurred in the course of a single transaction, it must prove, quote, either a temporal nexus between the murders, that is a continuity between them based on time, or that there was a plan, motive, or intent common to both murders. Now, while the state did not allege in its information that the murders occurred, quote, at the same time, that is not necessarily what the jury found, assuming that they followed Judge Gold's instruction. What they found was that these 2 murders were logically connected because they were committed close in time, or because the other circumstances, i.e. location, motive, weapon used, showed a common plan, motive, or intent to kill both victims. Based on this court's decisions in State versus Campbell and State versus Gibbs, what's clear is that the statute only requires that there be some logical nexus between the murders. And under Gibbs, this court held that a jury may consider temporal continuity as evidence that the 2 murders occurred in the course of a single transaction. To quote this court directly, and this is on page 606 of the Gibbs opinion, the court held that we conclude that although a temporal nexus between multiple murders committed by a defendant may constitute evidence that those murders took place in the course of a single transaction, such a temporal relationship is not an absolute prerequisite to prosecution under the statute. So it would appear from Gibbs that temporal continuity may be considered by a jury as evidence that the 2 murders occurred in the course of a single transaction. In Campbell, the court raised the issue of, well, if that's the case, doesn't it render superfluous the language same time? Because in Campbell, the court held that same time could mean simultaneous or sequential murders that are committed within a brief interval. And that's not I don't think that's necessarily the case. I think it was Justice Ecker who asked during a defendant's argument, could there be a situation where 2 murders occurred at the same time, but not in the course of a single transaction? It's difficult to come up with a situation. Just hypothetically, if the defendant, say, places a bomb in a car with the intent to kill the driver, but at the very last minute, unbeknownst to the defendant, a passenger enters the car, bomb goes off, both victims are killed instantaneously. That I guess could be a situation where same time could occur, but not necessarily in the course of a single transaction, but it's unclear. I see Justice Khan has a question.
Thank you, Counsel. Justice Khan.
Thank you, Chief. But that's no different than the example Attorney Rademacher gave, which was somebody shooting to kill one person. They fire multiple shots. They kill 2 people. It's still part of the same plan. It's transferred intent. You're just as guilty of murder, even though you didn't intend to kill the second person. But it was foreseeable if you shoot at a group of people, or if you place a bomb in a car and that bomb goes off to kill one person and either somebody else enters or the person enters with a second person or somebody standing near the car is killed, that's still part of the same plan. So that's not just based entirely on temporal proximity, is it?
I see Your Honor's point, and that's why the state posited in its brief that, this might be just the legislature's way of using two ways to describe the same conduct. And I think that's part of the problem that arose in cases like Gibbs and Campbell, where it's unclear whether these are two conceptually distinct phrases or just two ways of describing the same conduct.
But whether or not it is, in this particular case, there was evidence of both. There was never a dispute that these two people were killed within, I don't know, a minute, 2 minutes of each other at the most. Was there?
No, Your Honor. And there was never any dispute that these were two very close in time sequential murders. The evidence showed that the defendant parked his car at the intersection. The occupants of the defendant's car saw Mr. Cortez exit Ms. Ocasio's Honda. The two men met on the street. There was a very brief interaction between the two of them. The defendant shot Cortez and then immediately walked up to the Honda and fired inside, killing Ms. Ocasio. So it's clear that this was
that it was at the same time. And let's assume whether it's the defense's theory that it was Miss Opakala who did the shooting and not this defendant because she's the one with the axe to grind, or whether they believe the state's theory, the plan to kill is the plan to kill, whether they believed it was Opakala who did it or disbelieved that clearly because they found the defendant guilty and they were given a third-party culpability instruction. So the plan is, by finding the defendant guilty, the jury had to obviously believe that it was his plan or perhaps both of their plans, but not that it was Opakala. So in other words, the plan, whatever the plan was, that didn't change. What the jury was presented with by a way of defense, it just that it wasn't the defendant, that it was his girlfriend that did it.
Yes,
because she's the one that had the issue. That doesn't change the plan, which is to attack these people.
I would agree, Your Honor. The plan doesn't change depending on who the shooter was. And actually, there was evidence that the defendant was involved in this dispute too, that he had a dispute with Mr. Cortez about the prior incidents involving Ms. Ocasio's and Ms. Opalas's cars, the damage therein. So that's on page 28 to 29 of the October 25th transcript. So there was clearly a dispute between the two victims who were in a relationship and the defendant and his girlfriend, Ms. Opalas, over these prior incidents involving the damages to the cars. And there was also some evidence regarding Mr. Cortez selling fake marijuana under the defendant's name. So it's clear from the evidence that both the defendant and Ms. Opalas had a ongoing dispute with both of these victims. And that doesn't change, as Your Honor noted, depending on who the shooter was. Based on this court's holding in Gibbs, it would appear that temporal continuity can also be considered when the jury is deciding whether two crimes occurred in the course of a single transaction. And the use of the legislature's use of the words "in the course of," the state would argue that those words, by their common definition, would denote some level of temporal continuity. Because as this court held in Cobb, a murder that is committed in the course of a sexual assault means that the murder was committed either during or shortly after the sexual assault was committed. So the state would argue that the second alternative, that's the appropriate word to call it, also includes some element of temporal continuity. And therefore, the trial court's instruction to the jury that it may consider temporal continuity would not be necessarily improper and mislead the jury. Let's see here. If the court were to decide that these were two separate, conceptually distinct alternatives, then the state would have to agree that the instruction was improper, but it does not appear to be that way based on this court's prior decisions in Gibbs and Campbell. To the extent this court finds any error in the court's instruction on that element, the state would argue that Nader versus United States applies. This involves a an omission or misdescription of an element in an instruction, and therefore it is harmless if the evidence on this element is both overwhelming and uncontested. We have the following evidence that shows that this element was overwhelming. First, Ms. Ocasio was a witness to Mr. Cortez's murder. She was alive and at the scene when Mr. Cortez was shot. Under Campbell, that fact alone supports the jury's conclusion that these two murders were committed in the course of a single transaction, because the jury could infer from that the defendant murdered Ms. Ocasio in order to eliminate her as a witness to Mr. Cortez's murder. So that fact alone establishes that element. But the state presented additional evidence. These two murders were committed in the same manner, with the same weapon, at the same location, and within seconds of each other. We have evidence that the two victims were in a relationship. They had an ongoing dispute with the defendant and his girlfriend, Ms. Opalis, over drugs and prior incidents involving damages to the cars. Fourth, both of these victims were shot multiple times, which supports an inference that the defendant specifically intended to kill both victims. And in terms of the defendant's guilt overall, namely his identity as the perpetrator, the jury heard evidence that his DNA and thumbprint were on the murder weapon. He was the only occupant of the vehicle, the Nissan Altima, amongst the five who had gunshot residue on his person. A comparative analysis of the shell casings and projectiles found at the scene and from the victims showed that they matched the type of weapon used. The defendant, after committing both murders, bragged to the other members in the car that what he had done. He said, "This is how Joseph Silva does it." And he demonstrated to Ms. Villegas, another occupant, how he killed Mr. Cortez by pointing his finger at her forehead. Finally, the defendant went to extraordinary lengths to conceal his involvement in this crime. He hid the gun at his mother's house. He changed clothes at Walmart. He told everyone in the car not to say anything to the police just before they were arrested. So we have overwhelming evidence of the single transaction element. We have overwhelming evidence of identity. And finally, under the second prong of Nader versus US, this element was completely undisputed. The defendant never offered any argument to the jury that these were two separate and unrelated murders. There were no questions posed to any of the witnesses, nor was there any argument in closing from which we can infer the defendant's position that these were unrelated events that were not logically connected.
Counsel, I believe there's a question from Justice Keller.
Oh, I'm sorry.
Thank you, Chief. But your opponent argues that he contested that element vigorously and actually proved it didn't exist because he disproved the claimed motive, common motive. What do you say to that?
I would disagree, Your Honor, because he relied on the same evidence of motive to accuse Ms. Opalis as the murderer, and the state relied on the same evidence to accuse the defendant as being the murderer. The motive, as Justice Kahn indicated earlier, doesn't change. Both the defendant and Ms. Opalis had an ongoing dispute with these victims based on the defendant, the fact that he was dating multiple women, that there was damage done to both Ocasio's car and Opalis's car in the days leading up to the murders. So the defendant relied on this evidence to support his defense theory of third-party culpability. So I would disagree that the defendant challenged this motive evidence below.
Justice Mullins.
Just on that same point, in your review of the Nader cases, do you see the uncontested element being challenged simply by a defense that leaves the state to its proof to prove beyond reasonable doubt all the elements? In other words, is the element challenged
by the defense saying he didn't do it. So he's in effect challenging all the elements.
I would disagree, Your Honor. I believe that it was Thompson, which relied on Nader, that looked at the line of questioning from the defendant with respect to the state's witnesses to decide whether the element was contested. I suppose a defendant could argue that by saying I didn't do it, somebody else did, he's contesting everything. But I think the cases that rely on Nader look a little more closely at the evidence and the defendant's approach to that evidence. So the line of questioning from during cross-examination, closing argument, I think that's very appropriate for this court to review in deciding whether this was a contested element.
So your view of the cases is you have to specifically contest that element. Otherwise, if you're silent, if you say nothing, suppose there's no questioning on that element, your defense is simply, I didn't do it. That doesn't cut it in terms of contesting the element.
Correct, Your Honor. I would argue that there would have to be some indication on the record showing the defendant's, or at least showing an inference of the defendant's position on the element. If saying nothing, I don't believe, in my view of Thompson and Nader, that would suffice to show that the element was in contest. Here, because we have a silent record in terms of that element below, it's clear that this element was uncontested. And in fact, I would point to defense counsel's cross-examination of Ms. Opalis. When he cross-examined her, he asked her specifically, and this is on page 80 of the October 25th transcript, he asked her, did you murder Ms. Ocasio because she was a witness to Mr. Cortez's murder? So the defendant put it on the record to support an inference that Ms. Ocasio was murdered because she was a witness to the Cortez murder. So even if you go by that line of questioning, it shows that he would agree that these two murders were related, that they were not conceptually distinct, and therefore that would undermine his argument now that he was contesting this element below. With respect to the third issue raised on appeal, the defendant cannot show that the trial court's preclusion of argument on the state's failure to call Caraima Velez violated his constitutional rights. First of all, as Justice Doria noted, the defendant does have to request permission from the trial court before giving this type of argument, and that's clear from the Malave opinion itself. And that is because it is within the trial court's discretion whether to allow this type of argument. And there needs to be, as a matter, fairness just dictates that he puts the state on notice and the trial court on notice of his intention to do this so that there can be a discussion amongst the parties whether it is an appropriate argument on reasonable doubt. The defendant in this case never did that. He never requested permission or put the state on notice, even though the record shows that he intended to make this argument prior to the beginning of summations. He had included this argument on his flip chart that he used throughout closing argument. The trial court took note of that on the record. So even though he had planned this out ahead of time, he failed to request permission from the court or put the state on notice of his intention to make this argument. Now, as to the defendant's argument that this, oh, I'm sorry, I see Justice Keller has a question.
Thank you, Counsel. Justice Keller.
Thank you, Chief Justice. Is it harmless because he got to use the flip chart, or is it structural error as your opponent claims?
Is it harmless because he used the, I'm not sure I understand your question there.
You said he had her name on the flip chart, correct?
He had, yes, an argument regarding Velez on his flip chart.
All right, so does that render anything harmless here? Or if he really was prohibited from his right to argue reasonable doubt through counsel, do we have structural error, as he claims?
Well, let me take the second part of Your Honor's question first. This was not an intention to argue or an attempt to show a gap in the state's case or reasonable doubt, because Velez was not a witness whom the state naturally would call. She was not present for the murders. She did not see what happened. There's no indication whether she had any indirect knowledge of the murders after they occurred. So the state had multiple reasons for not calling Velez, and therefore to argue that our failure to call her showed reasonable doubt, I think is improper in this sense. On the contrary, the record more supports the fact that the defendant was the one who wanted to call Velez in the first place. He planned to call her, as Attorney Rodemaker noted. He sent a marshal to her house, and it wasn't the fact that the marshal couldn't serve her that failed to bring Velez in. He had spoken with Velez himself and decided not to call her. That's on page 69 to 70 of the October 29th transcript. So the defense counsel made the decision not to call Velez himself at the last minute. See, Justice Mullins has a question.
Thank you.
Are you done answering Justice Keller's question?
Oh, I should supposed to check with Justice Keller there. So, does that answer Your Honor's question, or there's?
Well, I wanted to know I think you argue in your brief that the fact that he got to talk about Velez in his flip chart and didn't have to take her out of his flip chart somehow mitigated any harm that might have been caused by Judge Rule.
I don't believe that was the state's intention. We used the flip chart evidence to show that this was an argument that was planned out ahead of time, and therefore he should have asked for permission for the court for doing that.
All right, thank you.
Justice Mullins, then Justice Khan.
My question is also in this area. I'm looking to try to find the argument, but you'll remember what the context was. Even if the trial court was right in that you had to ask permission for this, the trial court then allowed the prosecutor to make comments. And one of the comments the prosecutor made was, why didn't the defense call him, or something to that effect, or the defense could have called Velez. Is that right?
Our argument was specifically, and this is on page 90 of the October 30th transcript, when defense asked whether you would have wanted to hear from Velez, that was improper. You are not allowed to speculate as to why Velez did not testify, and you should know that both sides are free to call witnesses. That was the state's response.
Okay, so I guess my question is, do you think that last part went too far? I mean, the defense doesn't have to call any witnesses. It's the state's burden. So for the state to argue that both sides can call witnesses, do you think that went too far?
No, Your Honor. I think Your Honor is asking whether we possibly infringed on his right not to present evidence. I don't think that comment crosses the line there. I mean, it's a true statement that the defendant was free to call Ms. Velez if he so chose. But I don't think that crosses the line of perhaps infringing on a defendant's right not to present evidence. I've not seen a claim raised by the defendant with respect to that issue, but it doesn't appear that alone would be unconstitutional.
Anything further, Justice Mullins?
No.
Justice Khan.
Thank you, Chief. Correct me if I'm wrong, but as I understand it, the state's argument on harmless on this issue is that the defense's position is that if they had been allowed to argue the absence of Velez's testimony, it would be to establish that the dispute or the motive to hurt the two victims was held entirely by Opalak, meaning that Velez would somehow say the dispute between the parties was between Opalaka, and Velez through Ocasio and Cortez because of their friendship. And so the state's argument is they heard all about the nature of that relationship. In other words, the jury heard that Opalaka, and again, I'm sorry, I know I'm completely mispronouncing the name, but they heard that she didn't like Velez and Velez didn't like her because they were both dating the same man. and that they didn't like Ocasio and Cortez because of their close relationship to Velez. So they heard all the sordid details of these people's lives and relationships, correct? Is that part of the state's argument that it's not anything that the jury didn't hear?
Yes, Your Honor. I apologize to Justice Keller. I might have drawn a blank earlier when responding to Your Honor's question, but yes, that's absolutely correct. The jury heard all this evidence regarding a dispute between Velez and Ocasio, who were best friends, and Opalis and the defendant regarding these prior incidents and the fact that the defendant had multiple relationships going on at the time. So I don't see any way to interpret the defendant's argument here regarding Velez below as a comment on reasonable doubt or the state's failure to plug a hole in the evidence. The only evidence Velez could have offered here was evidence that would perhaps tend to incriminate Miss Opalis because she had a dispute with Miss Opalis. But again, Velez was not present for the crime. She did not see what happened. So she's not someone that the state would naturally call as a witness in this case. But in terms of harmless error, absolutely. I mean, the jury heard all this evidence regarding motive and the fact that the defendant was dating multiple women at the time. So it would not have made any difference in terms of the jury's verdict.
Okay, thank you. I yield back to the chief. That answers my question.
Thank you, counsel. Thank you, Justice Khan.
I know. I'm sorry, Your Honor.
No, you may continue.
Okay. I know we didn't touch upon issue 2 in defense counsel's opening argument, but just briefly, the trial court's failure to sua sponte give an instruction on the special credibility instruction concerning Miss Opalis was not plain error. Under Diaz, the failure to give such an instruction concerning such a witness, it cannot be plain error because it would have expanded the scope of existing law. There is no existing law for witnesses like Miss Opalis, who was neither a complainant, accomplice, or jailhouse informant. And alternatively, the trial court instructed the jury that she was a cooperating witness, that she was the focus of the defendant's third-party culpability defense, and the jury was well aware of her motive for testifying falsely in this case, based on the court's instructions and defense counsel's cross-examination and argument. So there is no plain error with respect to the court's failure to sua sponte instruct on Opalis's credibility. That's all the state has, Your Honor, but I'm happy to answer any further questions from the court.
Thank you, counsel. I don't see any questions. Thank you very much.
Okay.
Attorney Rademacher.
Well, I think the state has misrepresented what the defense was in this case as to the first issue. Appalach had been involved in the purchase of the murder weapon because when she tried to shoot out the windows of Ocasio's car with a BB gun, it didn't do much damage at all. The plan, if there was any plan that night, was they were driving around looking for Ocasio's car so they could take the gun and shoot the car's windows out. And the state argued to the jury that when Appalach got out of the car with the gun to shoot up a victim's car, and lo and behold to her, Cortez gets out of the car. And she had no intention of murdering anyone. But at that moment, he's coming towards her and she panicked and shot him and then shot the female victim in the car. So, yes, it was disputed that there was no plan that night to kill anybody. And the defendant had no knowledge ahead of time that she was going to kill Cortez or Ocasio. That was the main defense as to why he was not guilty. The secondary defense was, yes.
Thank you, Chief. Counsel, I have a question, and maybe you just misspoke. I thought you were summarizing the state's theory of the case. As I understand that the state's theory of the case was that Opalak had the gun, obtained the gun, then showed it to everyone in the car, and that the defendant was the one that got out of the car and did the shooting, and then bragged about it by saying, "This is how Joseph Silva does it." And I thought the defense's theory was that it was Opakala that got out of the car to shoot out the windows and didn't anticipate Cortez getting out of the car, then shoots him and then shoots her. So the difference between the theories is who got out of the car with the gun and shot whom. The plan doesn't have to be made days in advance, right? The plan can be formulated on the spot, just like intent to murder can be in seconds. Are you saying that the plan has to be some written out plan or a plan ahead of time?
No. What I'm claiming is that the defendant had no foreknowledge of what Opalak was going to do. That if there was a plan that night, this is what he said in closing argument, defense counsel said in closing, if there was a plan that night, it was to shoot up the car, and it went awry when the victims were in the car that night.
I guess that's my question. It doesn't matter whether the plan starts out with one intent and winds up being a plan of another. In other words, you can plan to rob somebody and then decide you're going to shoot them, and that your plan just changes slightly. You're going to shoot them and whoever else was there. So I don't know that makes a difference, counsel. I guess I was trying to understand how the state misrepresented
Because
your argument. I don't.
there has to be an agreement to participate in that robbery. If there's no agreement to participate in a robbery, then he can't be guilty on a felony murder theory. Here, there was no agreement ahead of time to shoot anyone. They wanted to damage the car. And then, in a split second, Opalak sees the victims and shoots them, and the defendant had no part in that.
But a plan doesn't have to be, a special circumstance doesn't have to exist in two people's mind. It can exist in one.
Maybe if he had said to her, shoot him, it'd be a different story. But there wasn't even enough time for him to say that.
But the jury didn't believe him. The jury didn't believe his story that it was Opalaka and not him that got out of the car. So
but there was discussion about it doesn't matter who the shooter is as long as they both have the same plan. I'm saying, yeah, it does matter who the shooter is when you don't have a plan to commit murder. And a capital felony like this can't be based on a felony murder theory. There has to be an intent to commit two murders. And he was not involved in that. Second of all, it was highly disputed here as to whether or not the defendant was involved in the feud between the victims and Ocasio.
Thank you, counsel. I know, I see both your time is up and my colleague, Justice Keller, has a question. I just wanted to let you know you've answered my questions.
Okay.
Chief, yield back to you.
Justice Keller?
It's not really a question. Thank you, Chief Justice. I just wanted to point out that your argument doesn't make sense to me, because the question is whether, if the jury determined your client was the shooter, did he have a plan? And what the state was saying was that, that you, throughout the trial, your client argued that plan all involved this, bad blood between the two girlfriends, or both of the girlfriends. So I think you're taking one step backward and trying to back out of saying that you never really argued there wasn't a motive, by trying to shift the motive to someone else. But that's not how the jury's going to approach this when it decides whether or not your client committed the multiple murder. I just wanted to point that out. Thank you.
My response to that is Opalak denied any hostility between her and the victims. Her best friend, Villegas, said no. She purchased the murder. They shot out the windows. There was a dispute here as to whether Opalak had an ongoing feud with Velez and Ocasio. Velez could speak to that issue in this case, and she did not testify. is being pointed out is the absence of testimony that could settle a factual dispute in this case. Thank you.
Thank you, Mr. Rademacher. Thank you, Mr. Sousa. With that, we're going to wrap up this argument. I want to thank both councils for attending. We really appreciate you coming in and doing this virtually. It really helps us to get to do our duties as a judicial branch. We greatly appreciate your participation into a virtual argument. We are in recess. I'm sorry. We are adjourned for the day. I will see my colleagues in the virtual conference room. Thank you very much.
Thank you, Your Honor.
You're welcome, Council.
Thank you.